SJC-10872, Commonwealth v. Robin Anthony Hoose.
Yes, Counsel. Good morning.
Good morning, Justices. Elizabeth Caddick for Robin Anthony Hoose. May it please the Court, I would like to start by discussing the preclusion of the false confessions expert witness. The trial judge erred mainly on requiring that there be a type of numerator and denominator proof that false confessions exist and that there be some type of arithmetic proof that factors that cause false confessions are absent in truthful confessions. And what the court did is require some type of formal, hard scientific evidence proof in a social science setting. And false confessions involve an interaction between generally the police and the defendant. It is based on actions by the police, by manipulation, at times
in
by...
this case, well,
Okay.
I thought there was an initial call and then before there was interaction, but go ahead.
Oh, okay. And then it, possibly in answer to what you were going to ask, that it also depends on the internal psychological makeup of the defendant or the external environment that the defendant finds himself in, which, you know, might be they're in pain, they've been interrogated a long time. And so there's this interaction that goes on. There's information given to a defendant or withheld. And so to plot all of this information into a numerator and denominator formula is impossible, but that doesn't mean that it can't be admitted as expert evidence. As you know, one of the courts has said, it's you can't say if tactic X then result Y. It doesn't happen in this type of case.
But didn't the judge, in addition to saying that she didn't think that she had the voir dire and she didn't think that the testimony was, that the expert opinion was based on a methodology generally accepted in the field, but also talked about there not being a fit between the false confession factors to which the expert testified in voir dire and this case. So isn't that an independent basis for the exercise of her discretion?
It could be an independent basis. This was also an incorrect finding because the expert had stated what factors in this case applied to what's known about false confessions. There was a suicide attempt just the day and a half before the interrogation. He was in a psychiatric, had just been released from a psychiatric hospital. He was suffering from depression, which is associated with false confessions because people have...
I was going to wait, but since you paused, I wanted you to wait to hear the factors and then to ask you, this is the situation in which he first called the police, correct? So you're talking about the applicability of those factors to events, interactions with police that were after he made the initial telephone call and made all these incriminating statements voluntarily before there was even any discovery of the bodies.
Right.
And you have to ignore that to make these things fit.
I don't see that because the statement that he made when he was in the hospital, in a psych hospital, right after he was admitted after a suicide attempt, he had sutures in his neck and his arm. He still had blood.
Some stitches and he got some anxiety medication.
He gave no specifics. He said that there are 2 dead bodies, and then he was asked, "Did you do it?" And he said yes, I'm not quite sure how, I know I didn't shoot them.
Did
Then
he say something about stabbed? Did
he said
say
I,
stabbed him?
he said I must have stabbed them because I know I didn't shoot them.
And he covered the woman. He gave quite
Right, and
some
that was
detail.
Detective Lassiter,
Right.
Lassiter, who said that he had many years of experience with Hoose. He didn't necessarily believe him. He was sarcastic about, oh, really, did you kill them? When Hoose said, are you going to arrest me? He says, well, let me check it out. Didn't necessarily believe him, testified at trial that Hoose had made up stories before.
But he did go to the house, right?
Well, sure. I mean, yes, that.
So he at least accepted it enough to follow through with an investigation.
Right. Now, challenging, if that were the only confession, challenging that would have been, at trial would have been a lot easier. You have someone who gave not a lot of facts that could be supported with the hard evidence, and it was in a psych hospital, only stated that he killed them in response to a question. But then you have at the trial the actual written statements, and then, of course, the recorded statements where some more information came in, and so it's the fact that there's police interrogation tactics that result in false confessions, but then the internal characteristics of the defendant just gives more credence to the false confession expert testimony for the police interrogation statement. But the defendant's own characteristics, which is the depression, where feelings of hopelessness, a foreshortened sight of the future. Obviously, he's suicidal. He doesn't really care about the future. He's hopeless. And there was testimony that he was doing crack cocaine through the night. The hours before the apparent, the murders, he had smoked crack cocaine 3 different times, which certainly is another factor that affects someone's false confession if they're either under the influence of drugs, which was argued that he was on psychotropic medications at the time of the statements, but also his ability to know what happened and to perhaps believe that he committed this crime when he didn't. The evidence was that he was out most of the night, came back, and at some point the 2 victims were dead, and
There was considerable evidence of other than confession. I mean, it isn't that there was one of those tunnel vision kinds of factors that was at play here, where the police said, oh, you must have done it, you've confessed, we're not going to look. They took the bloody clothes, the blood-saturated clothes, the hat, the whole business, right? And they checked for DNA.
But there was no question that he wasn't present at the scene of the crime. It was his house. But there was also the attempted third-party culprit testimony that, other persons could have committed the crime and had motive. The fact that the bodies were dead in his house and he discovered them, and that there was, transferred DNA from the victims, certainly isn't. It's not as if it was a scene that you wouldn't have expected anyone but the murderer to have been at. It was his home, and there was, testimony that people were in and out of the home, and in fact, someone who was mad at Hoose had even come that evening. Unimpeached testimony that someone who he had purportedly sold drugs to, but in fact sold something other than drugs, and came back angry at his house, were there when the 2 victims had been there alive. The false confession expert testimony only needs to raise a reasonable doubt as to the veracity of the confession. And that is what Dr. Redlich should have been able to have done. If there wasn't a great fit between, there was certainly enough of a fit between the factors that lead to false confessions and the factors in this case. The interrogation had gone on for over 6 hours, and there's a higher incidence of false confessions for interrogations that last, greater than 4 hours. But also, there was the issue of voluntariness. The defendant raised the issue of voluntariness of his confession. It was a live issue at trial. There was a jury instruction on voluntariness. And so he was entitled to have Dr. Redlich testify in order for the jury to determine whether his confession was voluntary. And as the jury instruction on expert witnesses states, it's for the jury to determine what weight they want to give the expert's testimony. And it wasn't, the judge precluded the jury from even hearing this
Don't we ask the judge to fulfill a gatekeeper role?
Yes, but
And so we don't put unreliable expert testimony, so-called expert testimony before a
exactly,
jury?
if it was unreliable.
And this judge determined that the methodology was not generally accepted in the field.
And that was incorrect, and so
But why
she
was
abused
that
her
incorrect?
discretion.
I mean, because there was one article.
No, absolutely not. There was not just one article. There was, the white paper was the culmination of years of false confession expert research and articles. There were dozens and dozens and dozens of articles about false confessions, the research involved, the investigation involved in them. And the white paper, it's a term used in scientific journals. It's the penultimate statement by the American Psychiatric Association, or American Psychological Association in this case, that we as a society, the Psychological Society, believe in this false confession research. This is the whole history of it. This is how we first discovered there were false confessions, didn't quite understand how this could happen, how someone could falsely confess, but also how someone could actually believe they committed a crime that they did not. And then as years went by, decades, they realized how this happened. And so the white paper was certainly not just the only paper on false confessions. As I said, it was the ultimate paper by the American Psychological Association adopting it. And as courts have said, the general, certainly there can be plenty of citations to appellate cases that have affirmed a judge's a denial of a false confession expert, and cases that go back, decades. But as one court had said, quoted in the brief, that simply because a scientific concept isn't generally accepted in the legal community doesn't mean that it's not generally accepted in the scientific community. And false confession research knowledge is generally accepted in the relevant scientific community.
And what is that relevant scientific community?
It is the psychologists in the United States. I mean, their association has accepted it. And if you look at the 8 pages of citations to the white paper, it lists all of the, well, not all, but the ones that they cited, research and articles, peer-reviewed articles on false confession expert knowledge. So now this court had in Robinson back in 80, well, I believe it was in the 90s, but it referred to the 1987 trial where an expert had, I guess, ineffectually stated what the state of the art was on false confession testimony then, but then 13 years later, I suppose it must have been 1997 was the trial, but in 2010 we know what the research was at the time of this trial. And so the court should not have based her decision on whether to admit this expert testimony based on older cases. She should have based it on the research and should not have based it on such a rigid calculation, such as requiring quantitative information, because there's also qualitative research, and that's what you would normally find in social science research. Now, Daubert, as explained in Kumho Tire, didn't expect that there be this rigid requirement of every type of expert testimony has to fit a certain type of formula. And that case had gone on to explain all the different types of expert testimony there is, including observational expert testimony, where someone's experience in just observing various things, such as tire wear and such. But also, this court has adopted and allowed and affirmed, for example, in Commonwealth versus Shanley, the dissociative amnesia concept, where the expert in that case, of course it was a Commonwealth expert, could not talk about numerators and denominators and could not state how many children who were not the victims of rape also had the symptoms of dissociative amnesia. This court has upheld
Of course, the judge in that case concluded that it should be admitted, and this is an abuse of discretion standard, as we know.
Right, right, and of course, the argument is that, the court did abuse its discretion here. When you're looking at a rigid formula, in fact, that's not really using your discretion, you're using a rigid formula, and so in that respect, she abused her discretion. And again, it was for the jury to decide how much weight to give to this, and I'd also now like to get to the change of venue argument, that the judge abused her discretion in failing to change the venue, particularly in the renewed motions that were made after jury selection began. This was a double homicide in...
How many of the Venaris said that they had read the paper and were excused for that reason?
Well, there...
Very few.
There were about, I could quickly add them up, there were about there were over 100 had said that they had read the article in the paper, but the judge did not dismiss people who read it, even people who had read it recently during that week of jury selection when there was an uptick in the articles in the paper, and the defendant was forced to use his peremptories to get rid of people who had read these sensational articles just recently. And so that was an error, because ultimately someone who had read the newspaper article just 2 days before, that article, 2 days before she was being picked for the jury, and in that article, we know from the record, it repeated his criminal history, his confession. Now, the confession, of course, was admitted at trial, and so that's, if that were it alone, that wouldn't be a problem. It's not as if it was suppressed.
You say sensational, and I think the decisional laws distinguishes between sensational and factual. So what makes this sensational as compared to factual?
Well, first of all, the fact that it's factual, that talks about his history, those facts would not have been allowed at the trial. So the fact that someone on the jury had read them, had read that he had a prior conviction for slitting a 17-year-old girl's throat when he's charged now with slitting the throat of the female victim in this case, that would never have come in at this trial. Even had he testified, I'm sure that particular crime would have been more prejudicial than relevant. The fact that he was deemed dangerous before, that he had assault and battery dangerous weapon charges, that wouldn't have come out at trial.
Did he exhaust his peremptory challenge?
Yes, he did. He asked for more. He was given one more. He used that up. then he was confronted with this juror who ultimately sat on the jury, who had read the paper 2 days before. We know that the paper had his whole criminal history again. She said that she read the Greenfield recorder every day, and she was asked, "Oh, can you, still have an open mind?" And she hesitated, and even in the transcript, it says pause, and the judge then states, "I see you're hesitating," and then the juror says, "Oh, yeah, but I can be fair." But as we know from what other jurors said, there was another juror who said she read about it, she discussed it with her friends, but she can still keep an open mind and not presume his guilt, and then later said, "Yeah, my friend and I discussed what he did." Well, obviously, she wasn't keeping an open mind about presuming his innocence if she already determined that he did the crime. I see that my time is up. Okay, thank you.
May it please the Court, Thomas Townsend for the Commonwealth. Unless otherwise directed by the panel, I'll address the venue question first, and then the false confession issue. There are ultimately two jurors, only two, who were ultimately selected who had had any exposure in the media to this case. One was Juror 301, who had read one article soon after the killings, and she had read that 2 people had been murdered, and that's the extent of it. She had read nothing since. The other juror, number 318, had read one article, had also learned that there had been 2 deaths, but she also learned that the defendant had called the police himself. That was not anything that was disputed at trial. She had not read anything since.
And when was that article published that she had read? Was that right after the events?
2 or 3 days after the
events?
The events, yes.
Okay, so these were both close in time to the events.
Correct. And neither one had read any articles since. Out of the jurors, the general questioning, that is, I submit, an incorrect measure to see who responded to the questioning. The correct measure is who is dismissed ultimately for prejudice. If we want to look at presumptive prejudice, the defendant has to satisfy that criterion, showing that the media had so saturated the potential jury pool that a significant number of the potential jurors were dismissed for prejudice. And this court has allowed up to 42% to be dismissed for prejudice and still not deem that there's presumptive prejudice. In fact, not a single case has reached this court where there has been presumptive prejudice. In this case, less than 10% of the jurors who were individually questioned were dismissed for media exposure. That is well below the 42% that this court has upheld, or the 25% that this court upheld in Morales, which was a much more sensational case that had to deal with the death of a police officer. This was a double homicide, but there was nothing sensational other than the fact of the killings themselves. And there, as the judge reported, there was an initial spate of stories soon after the deaths. Then it died down. There was a 3-year interval. I think there were 15 or 16 articles, predominantly from the Greenfield Recorder, and there were 2 articles in the Springfield Republican. There was some coverage of the motion to suppress in this case, but it was not sensational, it was not extensive. The defendant states in his brief that the publicity increased dramatically once the trial started. That is incorrect. On day 5 of the trial, the trial judge noted that there had been no article in the paper that day, no article in the paper the day before that. There was an article in the paper the day before that, but that had to do with an awkward, unusual instance where the entire jury pool was dismissed because there had been inappropriate handling of the juror questionnaires.
When you say the paper, are you referring to?
The Greenfield Recorder.
What about the Springfield Union?
I don't think that there may have been a reference, but I think when the judge was talking, she was specifically referencing the Greenfield Recorder.
Okay.
And that was the primary media source for I think there is one reference to a televised, something appearing on television and the Springfield channel, but there was no exposure to the jurors on that.
No, which juror read the article that contained information about his criminal history? Your sister mentioned that there was one article, a juror was selected, a juror was impaneled who had read, I believe she said this, who had read an article that contained some information that he had slit the throat of a 17-year-old.
No, the only jurors who were selected, there were the two jurors, as I mentioned, read an article soon after the killings. One didn't remember, there was no reference to the defendant at all. The other one was the reference to the defendant having called the police. And that's juror 318. And the other juror was 301. Those are the only two who ended up on the jury. The other jurors had no exposure whatsoever to this case.
Okay.
And so I don't think there's, well, that certainly goes to whether there was any actual prejudice. There was no actual prejudice.
So the articles that they read the same article, was it?
It's not clear that it was the same article. There were a series of articles soon after the killings.
And did they contain information that was not brought out at trial?
Some of the early articles contained some information about the defendant, about his criminal history. There was an article on, soon after the killings, on general article on how bail is determined, and it included information about the defendant and his past history. There's no indication that either of these jurors had read that. They told the judge what they had remembered. They had read nothing since. And the hesitation, the judge made a finding on the hesitation when she asked the juror, can you put that aside and apply the presumption of innocence? There was a little hesitation, but the judge said, well, the juror was taking that question seriously. That's how she interpreted it, and she gave an unequivocal answer that she could. And so I think deference should be given to the judge's determination on that. It wasn't a hesitancy where someone was wondering whether, indicating that they would not and were going to be untruthful to the judge. It was taking the question seriously.
And were there peremptories available to challenge these jurors?
Not the last juror seated. He did.
And that was, I'm just saying, of these two
Right.
jurors that you've identified, were there peremptories available for both of them or either of them?
I don't believe so, no.
So,
Not on 318. The defense attorney did ask for an extra peremptory. He was granted one. He asked for an additional one. And the judge asked, well, would you want another one after that? And he looked at the jury pool, yeah, I would want another. And she said, no, I already awarded you one. She opted not to award any further. And she had found that both of these jurors were impartial and indifferent.
Did they deliberate?
Those both jurors were deliberating jurors, yes. So I don't think there's a good, certainly not a good argument for presumptive prejudice here. The defendant repeatedly in his brief calls Greenfield a small town. Greenfield is the most populous community in Franklin County, is the county seat. There were jurors drawn from throughout the county. It was not sensational coverage. It was not extensive. It was a double murder. There was some stories early on, but in the 3-year period between the murders and trial, it was not extensive. And as, once again, the very fact that less fewer than 10% or about 10% of the jurors who were actually excused for cause due to their exposure to the media, that would cut against any claim of presumptive prejudice. And because only 2 jurors here were exposed to any media coverage at all, and that was benign and limited, there was no actual prejudice. So I urge this court to affirm the judge's finding on that. Unless there's further question, I'd like to turn to the false confession issue. The trial in this case was in 2010. 3 years earlier, in 2007, this court decided Commonwealth versus Robinson and affirmed the exclusion of another false confession expert, not Professor Redlich, but one of her colleagues. In doing so, the court relied on a couple of grounds. One was that there was no empirical data on the number of false confessions, and there also was no scientific basis to differentiate between false and true confessions. And this court concluded that the judge in that case did not abuse discretion in excluding that proffered testimony.
when was the trial in the Robinson case?
Robinson was 1997, took a while to get up here.
So the research
2007.
has changed since 1997.
Well, the arguments have not. in the interim, there has been the white paper, which the defendant relies on to a great extent. But still, the old criticisms and shortcomings of that field have not been remedied. Just last year, the Supreme Court of Michigan upheld the exclusion of a false confession expert for those very reasons, lack of scientific reliability. And I think the judge was warranted in having a hearing, and despite the publication of the white paper, and looking at the methodology, and concluding, as this court had concluded 3 years earlier, that it was lacking. In addition to the unreliability, there was also a basic fundamental lack of fit between the proposed testimony in this case. As was mentioned before, the defendant had called Detective Laster on his own and urged him to meet with him and confessed to the murders. That confession was in no way police-induced. Professor Redlich's testimony was not directed toward that first disclosure. It was directed to the station house interrogation. When the prosecutor during argument said that nothing that she said had anything to do with the disclosure of Detective Laster, defense counsel did not contradict that. Her proposed testimony was directed to the station house interrogation, but he had already, a day earlier, given the essentials of the confession. So it's not clear how this could be viewed as police-induced or even indeed as false.
Can I ask you, were the interrogations here recorded?
They were. And the court has them. It's video recorded, the entirety except for the one portion where it is being typed, his typed statement, that was audio recorded. But it's all video recorded, and this court has access. Of course, his initial confession to Detective Laster is not. But that was not a custodial situation. Detective Laster went over there more as a friend than anything.
And I take it that the defendant's mother called the detective first and asked him, please, to go and speak to
Right.
us.
She called the detective continuously over those 2 days. And finally, she got a hold of him, and the defendant was also on the line. He said, I have big news. You got to get over here. And he went over there, not knowing what to expect. And he was a little incredulous, but he believed enough to go to the Greenfield Police Department, get 2 people, and go over there. And he did find 2 people deceased, as the defendant had claimed. The locations were the same. They were stabbed victims.
Was the defendant taken into custody the moment he was released from the hospital?
No, there was, the judge made a finding that he went voluntarily. He had produced his mother as a witness who testified that it was involuntary, but there was police testimony that he went willingly and voluntarily. And the judge ultimately made a factual finding that he went voluntarily.
And was he placed under arrest after?
He was arrested after he gave his handwritten confession at about, it's at 3:06.
On the spot?
At the station.
At the station?
At the station, yes. He gave his handwritten confession. He had some pizza. The actual time of the arrest is 3:50 p.m.
And the conference he had with his attorney during the break, was that the only contact he had with his attorney during that, I think it was a 4-hour span?
Right, it was a 4.5-hour span. His attorney arrived, and he didn't know he had an attorney. CPCS, on their own initiative, appointed Attorney Masnick to go down to the station. First thing the defendant said when he heard about it is like, who's paying for him? I can't afford him. He met with Attorney Masnick for 15 to 20 minutes. The police immediately provided him access to the defendant, gave them a room in which they can confer, even though the attorney-client relationship was a little, I submit it's legally dubious, the appointment itself, but they went ahead and allowed him access.
I hope you're not relying on that for any.
I'm not relying on that on anything. That's not necessary for the purposes of this appeal. But he met with his attorney for 15 to 20 minutes, after which he stated that he wanted to continue speaking with the officers They went through the Miranda rights.
Did the attorney stay in the room while he was being interrogated from that point on?
No, he gave his card and he left and said, give me a call when he's brought into court. But he was re-Mirandized. During that day, he received Miranda warnings 4 times. He waived them all 4 times. Police were very cordial, and they let him disclose information at his own pace. After he found out he had been arrested, he was very hesitant during the 4.5 hours testimony. He had very clear memory about everything else, the days leading up to the killings. But when he got to the killings, he became awfully vague. He said, I think, or maybe. After he found out he had been arrested and was going to be transferred to the Franklin jail, he said, can I talk to Detective Lieutenant Gibbons? It's starting to come back to me now. He remembered the name of the woman. He remembered a lot of details. And unlike the first segment, the 4.5-hour segment where he took continuous breaks, I counted at least 8 breaks, either to go to the bathroom or smoke cigarettes. The second segment, which was about 2 hours, was workmanlike and businesslike, where he provided lots of information. He dictated a statement and he signed the statement. And there was a wide differential between his handwritten statement, which was very hesitant, and the statement he gave later, which was very factual and had a lot of information that he did not say he had remembered previously.
Is it clear that information came from him and not from the police?
Yes, and a lot of the information was not something involved things that the police would not have known otherwise.
Such as?
Such as he had said that the interview was interesting. Anytime he would say, I probably stabbed them, he would say, my ring, my watch, I don't know what happened to my ring or my watch. And ultimately, in his written statement, he stated that provided an impetus for the stabbing. He came home, found the 2 people there. They were not supposed to be there. Irene was using his cherished blanket. They had drunk his beer. The man was on his bed there watching TV, and his ring and his watch were missing. Well, as it turned out, the ring and the watch were on Irene. So the police would not have known that the ring and the watch provided an impetus for the stabbing. Likewise, the knife. When the police went to the scene, there was a bloody kitchen knife or steak knife in the living room near the 2 bodies covered with blood. Presumably, that would have been the murder weapon. As it turned out, that was not the murder weapon. That's a knife that he used to cut himself. The murder weapon was found behind the refrigerator. It had been washed off. The police just happened to look behind there as they were leaving. There's no reason they would know that 5.5-inch buck knife was the murder weapon. But the defendant described what he had done when he got so enraged at the 2 people for being there. He grabbed a nearby buck knife. He described it as a smaller type of buck knife, 5 to 6 inches long. That perfectly describes the murder weapon. And is also consistent with one of the witnesses who was there earlier in the evening, who described the defendant handling a knife which had tape on it and placing it near one of the victims. Presumably, that was as a means of defense in case one of the disgruntled buyers came back to the apartment. But it was nearby, so he said he grabbed the nearby buck knife. It was 5 to 6 inches long. The police, until after the autopsy, would not have known that would have been the murder weapon. So the defendant also provided that. And there are other details as well that the police would not have known of. But they did not apply him with information. The only information they gave him was they reminded him when he said he could not remember talking to Detective Laster earlier. They reminded him what he had told the detective. So that information they gave him, but he had already done that. He had already told Detective Laster that. They did not provide him with other information. I just want to go through a couple points on the false confession expert. At the hearing, defense counsel, there was a voir dire. Defense counsel, after about only 12 pages of transcript, was going to stop questioning the expert. She had given her background. She had given some particulars on the field of false confession, police-induced false confessions. And then the judge said, well, there's still that other component. You have to link this up to this case. And so then he went and asked the expert, well, what factors link up the false confession field to this case? And she focused on 4 areas. And one was confirmation by allegation or tunnel vision. And that occurs when the police will stop their investigation after the defendant had confessed. And she referenced a recent Illinois case in which they had stopped. They planned on doing DNA testing, but they had stopped once the person had confessed. Well, that is not present here. The police still conducted a thorough investigation. They still did the DNA testing. They still obviously did the autopsy. But they ran down other leads. Another second one was the lack of other evidence, where the confession stands alone. Well, here there was a mountain of other evidence, from the location and timing of the murders, to the bloody clothing, to his consciousness of guilt. The third one she referenced was the information came from other sources, not from the perpetrator himself. Well, as referenced just recently, the police did not ply him with information. The defendant provided non-obvious information. In addition to the watch and the ring and the knife, he also provided the information that he hit Frank with an object and rendered him unconscious. And that would not have been obvious to the interrogators. And also, she, for the fourth and last factor, she referenced the confession is inconsistent with the physical evidence. Well, that's plainly incorrect here. His confession is plainly consistent with the physical evidence, most notably the fact of rendering Frank unconscious before stabbing both of them to death. I see my time is up. Unless there's further questions from the panel, I'll rest my brief.
Thank you, sir.
Thank you.